Today's lecture is a case study on the right to health in South Africa. This is the third of three lectures on economic and social rights, or ESRs. Here's an overview of what we'll discuss. We'll see how the right to health is protected in the Constitution of South Africa. We'll then see how that right is interpreted by the Constitutional Court of South Africa in a very famous 2002 decision known as Minister of Health versus the Treatment Action Campaign. And finally, we'll consider whether this decision, the TAC decision, provides a response to the different challenges to viewing ESRs as human rights that we identified in previous lectures. Let's start with a review of the key provisions of the Constitution of South Africa relating to the right to health. And here you see them stated in quite broad language, but language that is phrased to provide everyone access to healthcare services. The second clause, section 27(2), provides that the state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of economic and social rights, including the right to health. You should immediately see significant similarities to Article 2 of the ICESCR. Now, the fact that the right to health is protected in a national constitution and the interpretation of that constitution is given over to a national court, in South Africa, the Constitutional Court, makes it possible for complainants to bring cases to court against the government alleging a violation of the right to health as found in the Constitution. So the Minister of Health versus the Treatment Action Campaign case is was based on one such complaint. Here, a number of pharmaceutical firms donated for free to South Africa nevirapine, which is an antiretroviral drug that significantly reduces mother-to-infant transmission of HIV during childbirth. Once the drug was donated, the government decided to restrict distribution of nevirapine to 18 pilot sites, and pregnant women who were elsewhere in the public health system were unable to receive the drug. The reason for the government limiting the access in this way was there was some concern about the development of resistance, some concern that if there was not counseling and follow-up, that women would transmit HIV to their children through breastfeeding. And also, I think it's fair to say, some suspicion about how effective antiretroviral drugs were going to be in any context. Now, the Treatment Action Campaign, which is a civil society organization, or NGO, in South Africa, which advocates for access to treatment and healthcare and support services for people living with HIV/AIDS. TAC had been advocating for these goals in South Africa for a number of years, but in the early 2000s, they challenged the government's policy of limiting nevirapine to these 18 pilot sites. And they alleged, in addition, that the government had failed to develop a comprehensive plan or program that would prevent mother-child transmission of HIV across the country. They filed a lawsuit in the national courts. In 2002, their case was heard by the Constitutional Court of South Africa, a new court created in the mid-1990s following the end of the apartheid regime in South Africa and the transition to majority black rule. The court issued what is really quite a historic and widely cited decision. And what I would like you to do now, before proceeding with the lecture, is to watch a short video on the TAC website about the background to the case, and also read a short excerpt of the decision itself on the Coursera webpage. Press play when you're ready to proceed with the lecture. Now, I'd like to review with you a number of interesting and important aspects of the case, because I think they do help to explain how the right to health could actually be subject to litigation in national courts, and possibly also at the international level as well. The Constitutional Court confronts a very basic question, and that's what is the role of the courts in cases alleging violations of ESRs? And in paragraph 37 of the judgment, you can see that the court thinks of itself as having quite a limited role because it's not institutionally equipped to make the kinds of political judgments about how public revenues and funds should be spent, and noting that there are many competing, compelling demands on the government's budget. Now, you might think, reading this paragraph in isolation, that the court would be signaling that it would not hear the case because it was not equipped in terms of its expertise and institutional competence and its political legitimacy to do so. But in fact, that's not the case. Although the court does refer to a restrained and focused role in adjudicating ESRs, that doesn't require a dismissal of the case. Rather, the court cites to Section 27, in particular Section 27.2 of the Constitution, and says that the court's role is, in fact, to review economic and social rights claims to ensure that the legislative measures that the government takes are reasonable. And that reasonableness reference is taken directly from the Constitution itself. So in short, the court does in fact have a role to play in deciding whether there has been a violation of economic and social rights. The next issue that needs to be addressed is exactly what the government must do to satisfy its obligations under the Constitution and its right to health, subject to review by the courts. Here, the Constitutional Court says that the state is obliged, again tracking the language of the text of the Constitution itself, the state is obliged to take reasonable measures progressively to eliminate the large areas of deprivation that afflict our society. So again, a focus on reasonable measures and a notation as well that there might be a range of reasonable approaches that the legislature and the government might adopt to meet its obligations in this regard. As long as those approaches are reasonable, the court will not second guess them. So that's the basic obligation. Now, what about the concept of the minimum core that we saw discussed in General Comment 3 of the Committee on Economic, Social, and Cultural Rights? There was a claim made in the case that the right to health in the South African Constitution does provide a minimum core of all ESRs, including the right to health. But the court said, no, that is not the case, that it would not be possible to entitle everyone to demand a minimum core of each of the ESRs in the Constitution. That is, even as to a minimum, something that simply is not practicable. So the court takes the position that a reasonable plan need not necessarily have a minimum core. Finally, the key question, as applied to the facts of the case, comes down to whether it's reasonable or unreasonable for the government to restrict nevirapine to the 18 pilot sites. And here the court answers that question by saying that, in fact, it is unreasonable for at least three reasons. First, the medical evidence, the consensus among the scientific and medical community, reveals that the drug nevirapine is indeed effective. Second, that the state has a negative obligation not to impair access to healthcare services. Here, the drugs that the pharmaceutical companies have made available to South Africa free of charge. And third, the fact that the program excluded a significant segment of South African society, here poor mothers and their children. And that made the plan unreasonable as well. So having determined that the plan was unreasonable, and thus that the government had violated Section 27 of the South African Constitution, the court then turned to the orders, and you can see them referenced in paragraph 135 of the decision, with respect to what the government must do to remedy those violations of the right to health. And the question I've asked of you is, do these orders impose both negative and positive obligations on the government? And you can see all of the orders listed at the end of the excerpt of the decision, And the answer to that question is yes, that the state must make available, together with appropriate counseling and testing services, they need to make available nevirapine at hospitals and clinics across the public health sector. So it's a negative obligation to the extent that the government is now allowing nevirapine to be freely prescribed by doctors across the public health system. But it's also a positive obligation in that the government must provide the counseling and testing services that would ensure that the drug is being used effectively both during childbirth and thereafter. So this leaves us then with a number of broader legal and policy questions. And I want to raise two of them for you before concluding today's lecture. The first is whether it's possible to reconcile the legal analysis in the TAC case with the analysis in the Committee on Economic, Social, and Cultural Rights General Comment number 3. And here I would say to you that I don't think it's entirely possible to reconcile the analysis. There are many similarities, such as the focus on legislative measures, the understanding of progressive realization, meaning the adoption of a plan that affects vulnerable groups in society, but in particular the idea of a minimum core obligation which, according to the committee, each state party to the ICESCR must provide immediately to everyone. That is a concept that the Constitutional Court of South Africa essentially rejects in the TAC case. So in that sense, this is a competing way of conceptualizing economic and social rights. It's not necessarily a better way, but it is a way that is developed by judges who are perhaps more closely in tune with the needs and competing claims within a particular society. And I should note that there are other courts around the world that have adopted the view that the minimum core should be provided. So this is still an ongoing dialogue among different actors in the international legal system. Second basic policy question is, does the TAC case overcome any or all of the 4 challenges to ESRs as human rights that we looked at in previous lectures? The universality, political process, vagueness, and justiciability challenges. And I would submit to you that the answer to that question is yes, certainly with respect to political process, vagueness, and justiciability, perhaps less so with respect to universality for the reasons that I just explained with regard to the first question. With regard to political process, well, the court is quite deferential to the legislature, but it follows the mandate given to the court in the Constitution to ensure that the government has a reasonable plan. The reasonableness of the plan is subject to review by the court. The court gives a number of factors and considerations that the government must take into account, and that also helps, I think, to deal with the vagueness challenge. And the very fact that you have a court adjudicating a case and issuing concrete and specific remedies overcomes the justiciability challenge. In sum, I think it's fair to say that the South African court decision heralded a broader range of national and international litigation across the world relating to the right to health. And on this final slide, I've given you a number of sources that you might wish to consult that will take you to some of those other cases in which the right to health has been adjudicated.